deciding to pursue a claim for breach of contract in an agreement between two or more parties is a complex decision. It requires a deep analysis, not only as to what your rights are under the agreement, but what are the real-world practical consequences of you initiating such an action. Whenever a lawyer gives legal advice, he has to understand that there is a corresponding business consequence to that advice. And likewise, when a client makes a business decision or you give a business advice, there is a corresponding legal consequence. So you have to consider if the party which you have a relationship with has breached the contract. First and foremost, is the material breach. Is it a material breach? Is it that important that it goes to the essence of the contractual relationship? If it does, and it impacts your ability substantially, then you may be leaning more towards doing it. But what about if it's a non-material breach of a material breach, meaning that it only happened once. It didn't happen every day. It doesn't happen every month. You only lost $1,000 in the transaction, but the relationship is generating millions of dollars for you. Yes, you do have a breach of contract case, but there's a business consequence that's much more valuable than what benefit you're going to gain from proving that you're a great lawyer and you're going to win a case that, yes, you're going to win at great cost. It's what we call a Pyrrhic victory. You cannot make a decision to pursue a breach of contract case in a vacuum. You have to think of the business consequences.